Sundown. For the news, views, opinion, debates, and discussions, listen to Who is Who, talking about issues that affect our country and continent. Only on the Sundown, your eye on South Sudan.
Hello and welcome to the Sundown Show on Radio with me, Madrama James. Today is Monday, the 29th of September 2025. We begin the show here in Juba, where the official trial of suspended First Vice President Dr. Riek Machar and his co-accused is set to commence on Wednesday after the special court rejected multiple legal objections raised by the defense team, including a challenge to its jurisdiction and the constitutionality of the proceeding. In a landmark ruling delivered on Monday, presiding judge Dr. James Alaladeng overruled all 5 objections brought forward by the defense, paving the way for the case or criminal case number 1533 of 2025 to proceed. And let's hear more from Dr. Justice James Alaladeng.
It is evident from the submissions that main points for the determinations are to be discussed as follows. Number 1, reading warrant of the establishment of this special court and argument of defense and prosecution, the court believes that there is no overlapping of jurisdiction between its competency and the one of hybrid court for its twice offenses committed in Nasser incidents in March 2025, and that hybrid court have jurisdiction within with respect to genocide, crime against humanity, war crimes, and other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence, as provided for in the Transitional Constitution of the Republic of South Sudan, 2011, Amendment number 6, 2020. The Constitution made it clear that the hybrid court shall be independent and distinct from the national judiciary in its operations and shall carry out its own investigations. The hybrid court shall have primacy over any national court of Republic of South Sudan, of course, when a conflict of law arise. So, the hybrid court has jurisdiction to investigate and prosecute in respects with individuals who violated applicable laws of South Sudan, which are relevant according to Article 5.3.1 and 5.2, from 3.2.14 of the Revitalized Agreement of 2018. It is obvious now that those applicable laws of South Sudan and its other relevant laws have not been identified or named in the revitalized agreement on the resolution of the conflict in the Republic of South Sudan in 2018. It follows that failure of the revitalized agreement itself to specify, those applicable South Sudan laws and relevant laws of Republic of South Sudan made it difficult to understand the specific jurisdiction of the hybrid court itself in regards to the laws of the Republic of South Sudan, which fall within its jurisdiction, domestic laws. The hybrid court for South Sudan have not yet been established, and it is not clear when it will be established. National courts of South Sudan are operating and exercising their constitutional mandate according to the provisions of Article 122, sub-article 1 and 2 and 4 of the Transitional Constitution 2011 as amended, as long as they have not been suspended or withheld from doing their work by the hybrid court, which is in actual fact is not existing, since the national and hybrid court are independent according to the provisions of the Article 5.3.2.2 of the Revitalized Agreement 2018. The special courts enjoys jurisdiction to try this case according to the Constitution 2011 as amended. Number 2, as for the jurisdiction and competency of the President of the Supreme Court to constitute a special court to try Nasser incidents, offenses, the law is clear that he or she has the power, bearing in mind the separation between hybrid court and national courts, as is stated above. To explain, the President of Supreme Court of the Republic of South Sudan established Nasser Special Court according to provisions of Article 124, 122.4, 126.2, G3, and 127.1b of the Transitional Constitution 2011 as amended, in addition to the provisions of Section 16.4 and Sections 44 of the Code of Criminal Procedure Act 2008 and Section 11.3.7f of the Judiciary Act 2008. Therefore, the court has jurisdiction and competence to try the accused persons, since the wordings in the Revitalized Agreement 2018 and Transitional Constitution 2011 Amendment number 6, 2020 says that the word that from 15th December so through the end of the transitional period is not meant to help or to hold back states' hands in addressing crimes, even if the hybrid court is active. The national courts have the jurisdiction and the powers to prosecute offenses within the territory of the Republic of South Sudan. Therefore, it is the evidence that is the stick yard to prove whether the subject matter of the trial belong to the hybrid court or national courts. Number 3, concerning the lifting of immunity of the first vice president raised by the defense based on Article 103, 104, 2 of the Transitional Constitution 2011 Amendment number 6, 2020, and Rule 62 and 63 of Transitional National Legislative Assembly Conduct of Business Regulations 2013 Amendment 2021, which provides that the first vice president should not be subjected to criminal proceedings while in the office, except upon proper removal of the immunity by a resolution passed by 2/3 majority of all members of National Legislative Assembly. The prosecution replies to these claims in their submission. In pursuant of Article 106, 1 and 106, 104, 103 and 104, 2, the Constitution 2011 has amended, and provisions of 62, 63 of the National Assembly Code of Business, Article 103.1 confers constitutional immunity upon the President of the Republic of South Sudan only. And Article 104.2 of the Constitution is dealing with appointment and removal of the first vice president. The provision did not expressly or directly mention immunity of the first vice president and other 4 vice presidents. As for the provisions of rules 62, 63 of conduct of business stated above, 62 deals with impeachment of the President of the Republic, and Rule 63 of the same deals with the removal of the first vice president and the 4 vice presidents. The 2 rules cited by the defense do not talk about constitutional immunity of the first vice president, because the constitutional immunity is created or granted by the Constitution as the supreme law of the land in the hierarchy according to provisions of Article 3(1) of the Transitional Constitution 2011 as amended, which reads, this Constitution derives its authority from the will of the people and shall be the supreme law of the land. It shall have a binding force on persons, institutions, organs, and agencies of government throughout the country. Therefore, provisions of the National Assembly Code of Business 2013 as amended is a subsidiary legislation. It governs internal conduct of business of the Assembly, which is subordinate to the Transitional Constitution 2011 as amended. And therefore, it doesn't create or grant constitutional immunity to anybody in the country. On the contrary to the Constitution, for the above mentioned reasons, the first Vice President does not have constitutional immunity according to the provisions of the Transitional Constitution. Therefore, the objection is rejected.
Dr. Justice James Alala Adeng announcing there. However, the court dismissed the hesitation, stating that the hybrid court for South Sudan has not yet been established, and therefore national courts remain fully competent to adjudicate criminal offences committed within the territory. Judge Alala said the special court enjoys jurisdiction to try this case according to the Transitional Constitution 2011 as amended. Meanwhile, the government prosecution team has officially unveiled grave criminal charges against Dr. Riek Machar and several high-ranking military officials in relation to the March 2025 Nasir violence. More from Joe, who is the lead prosecutor.
On the 3rd through the 7th of March 2025, in Nasir County, Upper Nile State, the people of South Sudan and the world witness the gravest crimes that strike at the very heart of our constitutional order, endangered our national security, and traumatized and inflicted immeasurable suffering on the people of South Sudan. The government military garrison in which Yardio, Nasir was attacked and overrun by the White Army militia. The government forces that surrendered on their own and those that surrendered on the persuasion of the chief accused person, Dr. Riek Machar, including the late David Maju, who was to be evacuated by UN helicopter. Those injured and those captured alive were rounded up and executed at point blank. The dead were dragged around and others dumped into the river and others left to rot where they were executed. My Lord Justices, on April 20th, the South Sudan People's Defense Forces, SSPDF, regained the control of Nasir town and Wichyardiu military garrison. At Wichyardiu garrison, they were welcomed by the dry bones of their slain comrades, an apocalyptic scene comparable to the biblical phrase of Valley of Bones. But here, my lords, it was a barbed wire garrison, a plain land of bones overlooking the silent and green river. The prosecution stands before you today on behalf of the People's Republic of South Sudan to seek justice for these heinous crimes committed by the accused persons. My lords, justices, this case is about individual criminal acts or omissions or responsibilities of the accused persons. I emphasize individual criminal acts or responsibility of the accused persons. The accused persons are namely Port Kanchol, Lieutenant General Gabriel Droblam, Mampal Duor, Garawich Lamport, Dr. Riek Machar, Brigadier General Camilo Gadmichael, First Lieutenant Mading Riak Yak, and Lance Corporal Dominic Gadgokriak, who are present before you here, and others who are at large, namely Lieutenant General Peter Tokchuo Lwak, Major General Dilin Care Cholkuj, Major General Peter Roach Wibien, Lieutenant General Ye Dak Wiu, Major General William Dengpom, Kang Makana, Major General Kong Miang, Kwang Terjet, Garawich Liam, Biel Wiu, James Galwak Liu, Brigadier General Hogdor Chuol, and Pal Mai Deng. My Lord Justices, investigations were conducted of over 100 people, and the rest were released, and only these were the ones the prosecution has presented before this court to have been found culpable in the criminal acts that they are being charged with. In due course, Mr. Presiding Justice and distinguished members of the bench, the prosecution shall seek the indulgence of this honorable court to permit the prosecution of those absent and at large in absentia. The honorable Presiding Justice and distinguished members of the bench, the incident in Nasir in March 2025, characterized by brutal mass murder in cold blood, inhumane treatment, and total disrespect of the dead, and total disregard of the laws of South Sudan, remains unforgettable and regrettable stain in the conscience of this republic. My Lord Justices, the prosecution will demonstrate that these were not spontaneous attacks, but actions of well-organized, well-financed, brutal criminal scheme. A criminal scheme carried out by the accused persons as they incited, organized, abated, financed, and weaponized a militant group, the so-called White Army, to target SSPD personnel, civilians, and undermine the government. My Lord Justices, the prosecution will avail evidence that the White Army did not act independently. They were under the direct command of the fourth accused person, General Gabriel Droblam, Major General Dilin Care, who is at large, and the fifth accused person, Dr. Riek Machar, and financed by the first accused person, Mr. Port Kanchol, and Mampal Duor, the third accused person. The attacks by the White Army were planned, funded, coordinated, and commanded by some of the commanders of SPLA-IO. We emphasize some of the commanders of SPLA-IO. The commanders in Juba coordinating the assault were Lieutenant General Gabriel Droblam and Major General Dilin Care. And on the ground in Nasir, the SPLA-IO officers commanding the White Army were namely the late Torgel, Ton, Kang Makana, who is at large, Lieutenant General Peter Tokchuo, Brigadier General Manpinj Pal, Brigadier General Peter Palmut Yaj, Bol Doyak, and Major General Kong Moyang. This means the attacks were executed under the direct orders of the fifth accused person, who is the Commander-in-Chief of the SPLA Air Forces. The evidence the prosecution will present will establish this clear and undeniable claim and the chain of command. It will demonstrate that the militant White Army operated under the direct command and influence and the strategic direction of the accused persons before you and those at large. My Lord Justices, there is a false narrative that this trial is a political witch hunt against the fifth accused person, Dr. Riek Machar, and the other accused persons. Contrary to this claim, my lords, this trial is about the rule of law. It is about giving justice to the victims. It is about having a closer to the victims, fighting impunity, and setting a new departure that crimes must be punished, that there must be a new chapter of accountability for all, regardless of status. Albeit this, it is inversely an opportunity for the accused persons as well to clear their names. In this commitment to the rule of law, my lords, the accused persons before you are presumed innocent as per our constitution until found guilty by this competent court. It is to this commitment that this trial is open to the public. Further, my lords, it is to this commitment that the accused is duly represented by a competent defense team, and the Republic of South Sudan is willing and in position, given the nature of the offenses herein, to assign lawyers in addition, if need be, to defend the accused persons. The Honorable Justice and the distinguished members of the bench, the accused persons, Port Kang and others, stand charged with treason, concealing treason, subverting the Constitution, insurgency, banditry, terrorism, terrorist financing, mass murder, destruction of protected property, treasury, attacks on United Nations personnel, unlawful seizure of a military garrison, and participation in an organized criminal act. These charges, my lords, are brought under the Penal Code Act 2008, the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024, the National Security Service Act 2014 as amended in 2024, the SPLA Act 2009 as amended in 2020, and the Geneva Convention Act 2012. The prosecution will provide evidence proving beyond reasonable doubt that the accused persons committed the said crimes, and that the crimes are: 1, a crime of treason. Instead of paying allegiance to the Republic of South Sudan, the accused persons waged war against the state with intention to overthrow the constitutional government contrary to sections 64, 65, and 66 of the Penal Code Act. That the accused persons engaged in terrorist acts. The accused persons committed violence with the intention of causing forcible resistance to the government and to the defense forces and any lawful agencies, as well as possession and using dangerous weapons, contrary to sections 67, 70, 71 of the Penal Code Act. That the accused persons engaged in terrorist financing, the accused persons collected and provided funds with the knowledge that they would be used for terrorist purposes, contrary to section 14, 15, and 16 of the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024. That they committed mass murder. The accused persons abated the brutal and inhuman killings of armed SSPDF and wounded personnel, including the late Major General David Major Dak, the commander of SSPDF in Nasir, a UN personnel member, and 257 SSPDF personnel in Nasir, in violation of the Geneva Convention and the Penal Code Act, sections 10 and 206 respectively. That they committed as well destruction of protected property by damaging UN-marked helicopters, destruction of military equipment and civilian assets, contrary to section 67 of the Penal Code Act and the United Nations Convention on the Safety of United Nations and Associated Personnel, 1994. And that they committed treachery by consciously giving confidential information to the SPLAIO commanders on the ground and in Juba, and withholding vital information from the SSPDF command, contrary to sections 64(1) F and G of the SPLA Act 2009 as amended in 2022. My lords, in terms of evidence, the evidence will point a picture of calculated violence that extended beyond military targets. It will detail gross violations of the Geneva Convention, including desecration of the dead and persecution of innocent civilians and UN workers. The prosecution will present a layered evidence strategy, beginning with testimonial evidence that will come from survivors, eyewitnesses, and protected witnesses who will recount the attacks, the planning meetings, and the consequences they endured. The prosecution will provide documentary and physical evidence like signed operational orders and autopsy reports. The prosecution, my lord, will provide digital forensic evidence like call records, WhatsApp communications, preserved and authenticated in compliance with international standards and international evidentiary standards. The prosecution as well will present expert testimonies from forensic pathologists, from digital forensic specialists, from military experts that will assist this honorable court in understanding the technical aspects of these crimes. This evidence will be presented chronologically, from the planning to the funding to execution to the aftermath, ensuring that each strand corroborates the other and eliminates reasonable doubt. My lords, the prosecution will meet this with the independent corroboration of witness statements, forensic and biometric evidence, authenticated through metadata, hash measures, hash values, and expert verification. In terms of procedural standards, my lords, the prosecution will assure the court that every exhibit is supported by an unbroken chain of custody. Vulnerable witnesses will be protected, including through in-camera testimony when necessary. In conclusion, my lords, this trial is a testament to our nation's unwavering commitment to the rule of law and to breaking this cycle of violence and impunity. The accused persons have been informed of their rights and their right to fair trial. We operate in strict adherence to our constitutional standards and our obligations under international law. This trial, my lords, is about accountability, justice, and the rule of law. The evidence will prove that accused persons deliberately conspired to wage war against the state, terrorize civilians, and undermine the peace and security of South Sudan. At the conclusion of this case, my lords, notwithstanding the presumption of innocence of the accused persons before this honorable court, the prosecution shall respectively request conviction on all principal charges and the imposition of sentences proportionate to the gravity of these crimes, consistent with South Sudan laws and international standards. Allow me, my lords, to return the mic to you, if any, for the defense team to exercise their right of reply to our statement, and thereafter to the investigator who shall journey us through the process of demonstrating the evidence that shall be demonstrated before this honorable court to prove the charges against the accused persons. With this, my lords,
Well, that was elite prosecutor Joe Ohisa. For his part, Dr. Gary Raimondo, a senior defense counsel for Dr. Riek Machar, has cautioned the special court against bias in the prosecution of the suspended first vice president and his co. Speaking during a procedural hearing at the special criminal court in Juba, Dr. Raimondo said the role of the prosecution must be grounded in justice, fairness, and public interest, not driven by the pursuit of conviction at any cost. More from Dr. Gary Raimondo Lege, defense lawyer.
It seems that the prosecution have forgotten about natural justice. And natural justice, the element of natural justice are two. One, OD altrum patrum, which means do not condemn somebody unheard. Second, nemo judice in propria posa, which means a monkey should not determine the affairs of the forest, which means rule against bias, which is part of Article 19 of our Constitution. The right to be heard is enshrined in the Universal Declaration of Human Rights, 1948. It's also enshrined in the International Covenant for Civil and Political Rights of 1966, read together, International Covenant for Social, Cultural. Are you forgetting our rights?
Please, continue.
We have spoken, and this is my time to talk.
It's okay. Please shorten your response.
Thank you, my Lord.
Yes.
My colleagues, Your Lordship, the prosecution alleges that our clients and 8 accused are guilty of serious offenses under Chapter 4 and 5, Section 206, 239 of the Penal Code, read together with Section 15A, B, and Section 16 of the Money Laundering and Counter-Terrorism Act 2012 as amended, read together with all the sections mentioned in the charges. To succeed, the prosecution moved from must prove beyond reasonable doubt that the accused person committed each and every element of the alleged offenses unless and until the prosecution discharge that burden, the burden of proof lies on them to certification of this special. The presumption of innocence must prevail. First and foremost, Your Lordship, and before we indulge into the fact and the law applicable, we would like to emphasize on the role of prosecution attorney, because criminal law or penal court involve a contest between the state and accused person. It is imperative that both sides are represented by competent and ethical advocates or attorneys. The primary duty of lawyers for state prosecution and the accused or defense is to assist the court and the process and not to their respective clients as such. Thus, both sides have essentially similar obligations, although they come to their task from different perspectives. Your Lordship, a prosecution represents the state, not the victim. His or her duty is not to secure conviction at all costs, but to ensure that all the evidence fairly and accurately adduced before the court of law. Your Lordship, a prosecutor is the Minister of Justice who represents the government in the public prosecution according to provision of Article 135, Clause 3 of the Transitional Constitution of the Republic of 2011 as amended. The prosecutor principal's role is to assist the court to arrive at the truth and to do justice between a community and the accused person according to law and the dictates of her. A prosecutor is not entitled to act as if representing private interest in litigation. A prosecution or a prosecutor represents a community community of South Sudan, and not any individual and sexual entity. A prosecutor acts independent, yet in general public interest. The prosecutor interest is to be understood in that context as in historical continuum, acknowledging debts to previous generation and obligation to future generation. Your Lordship, in carrying out that function, it behoved him neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, which credible evidence means believable evidence, reliable evidence, trustworthy evidence, evidence acquired according to law, not unconstitutional evidence or illegal obtained evidence, which will submit to this honorable court in due course. Let me repeat again. In carrying out that function, it behoved him, the prosecution, neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, nor to do even a little wrong for sake of expediency, or to pick any person or please any power, not to be either illegal or suspicious, intolerant or overplanned, as we have realized from our colleagues there. In the firm and abiding mind to do right to all manner of people, to seek justice with care, understanding, and good confidence. They should not be biased to the government. They should be biased to the people of South Sudan. Restore justice in this nation, this beautiful nation of ours. Your Lordship, it cannot be overemphasized that the purpose of criminal prosecution is not to obtain a conviction. It is to lay before a court credible evidence, relevant, related, connected, and linked with the facts. One of the ingredients of the elements of the crime, which all of us, we know in this room, actus rea, mens rea, and causation. We need our colleagues there to stick to these three elements, ingredients of the crime. Mens rea, actus rea, mens rea, and causation, which means physical act, criminal guilt, and connection between the act and the deed and the result. Your Lordship, lawyer has a duty to see that all available legal proof of the fact is presented. It should be done firmly and pressed to its legitimate strength, but it must all be done fair. The role of the prosecution excludes any notion of winning or losing. His function is a matter of public duty than which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and justice of judicial proceeding. Your Lordship, furthermore, Lord Macmillan, a Lord Advocate General in Scotland, and a member of the Judicial Committee of the House of Lords of England. So this Lord says, we, in the discharge of his office, the advocate has a duty to his client who are here, a duty to his opponent who are there, a duty to the Honorable Court, a duty to himself, to myself, ourselves, to respect this honorable, noble God, and a duty to the state, our country, the Republic of South Sudan. We are here for that. Your Lordship, the accused person prior to their arrest were subjected to politicized media campaign, outrages by ministers, politicians, and senior officers. In that campaign, explicit accusations were broadcast against them. The media broadcast against them to the public. This conduct amount to unlawful and prior conviction of our accused and a blatant violation of the constitutionality guarantee presumption of innocence, which is stipulated in Article 19, Clause 1 of our beautiful Constitution, read together with Section 6 of the Code of Criminal Procedure 2008, Laws of South Sudan. The accused is innocent until it is proved beyond reasonable doubt. And for our colleague, let me tell you from here, what is the meaning of beyond reasonable doubt?
Please, let me
conclude. Moreover,
You just try to conclude.
it is just only 3 lines. I want to remind this honorable court that South Sudan belongs to common law, and judges always make law in the absence of procedural fair. We have to do that to our country. Moreover, the defense records that the investigative authorities proceeded to arrest, interrogate unlawful search, and charge the accused person before their constitutional immunity had been duly lifted, and only thought to cure this defeat respectively. This violates the principle of legality, as a principle firmly recognized in our jurisprudence that what is built upon illegality remains invalid. It is null and void, ab initio, ad limine, from the beginning. Any such without due process of our Code of Criminal Procedure to our clients here are considered to be null and void, ab initio. Your Lordship, in addition, this case has placed the government in a position of embarrassment. It has been brought forward without proper official rights and without the request procedural foundation. This has left the public prosecution exposed to the extent that it risks withdrawal. This scenario mirrors a well-known precedent in which their late colleague, distinguished counsel, our late colleague, Charles Deng, our brilliant lawyer of this country, who passed on. He rejected to represent the government in the case of Asma Mahmoud Mohamed Taha and others versus government of Sudan in is published in the Sudan General Report 1986, where it was affirmed that the prosecution cannot sustain a prosecution in the absence of proper legal foundation. Honorable Justice of this Honorable Special Court, justice is neither proclaimed from political podiums nor declared in security offices. Justice is dispensed in the courtroom, beautiful courtroom like this, such as this special court under the rule of law. And the rule of law, our professor Albert Van Dicey has come with his book about that. Your Lordship, a matter of fundamental importance arises in this proceeding, namely the manner in which the prosecution intends to establish that accused person is standing before this special court are responsible for alleged crime, of which crime scenes in Nasir, in the Upper Nile State. It is undisputed fact that the said location is situated at a distance approximately 712 kilometers from the city of Juba, where all these are here and Nasir is far. How they manage, they fly up to there and come. We don't have transport from Juba to Nasir, we don't have a road. How they manage to go there, the burden of proof lies on he who alleges to prove the case beyond reasonable doubt. Your Lord, the accused person has been detained since March 2025 up to 21 of September 2025 in a clear violation of their constitutional right. A person arrested by the police as part of investigation may be held in detention for a period not exceeding 24 hours, and if not released on bond, to be produced in court according to provision of Article 19, Clause 4 of our beautiful Constitution of Republic of South Sudan. Number 2, every person shall have the right of a fair and speedy trial, and justice shall not be delayed pursuant to provision of Article 122, Clause 5, Paragraph B of the Constitution, our Constitution, read together with the provision of Section 6A of the Code of Criminal Procedure Act 2009. Number 3, Every accused person is presumed innocent until his or her guilt is proved beyond reasonable doubt in accordance with the provision of Article 19.1 of the Constitutional Constitution 2011 as amended, and I forget with the provision of Section 6P of the Code of Criminal Procedure. Number 4, no punishment shall be inflicted upon any person exceeding the prescribed by the law in force at the time such offense was committed. The prosecution of any dispute is fine with political rhetoric and general description lacking material evidence, real evidence, and the legal element of alleged crime. In conclusion, we will respectfully invite your honorable special court to render.
Well, Gary Raimondo, defense lawyer, responding right there. Now, the trial is set to resume on Wednesday with the first prosecution witness expected to testify. Now, the defense has indicated it will continue to challenge the evidences and the credibility of the investigation process, and iRadio will equally keep you updated. Dear listener, up to here it has brought us to the end of the special court proceeding for today on Dr. Ria Kamachara and his co-accused in relation to the Nasir incident, and we will keep you informed. Otherwise, thank you so much. And that also brings us to the end of the first hour, and thank you so much for listening. In the second hour, we shall be crossing over to that's a peace-related initiative right here in Central Equatoria State. I've been your host, Madrama James.
شكرا لكم مستمعين